And there's definitely more respectful ways to speak to the person who could put you in prison for up to 20 years. I don't have to go along with this plea agreement right now. Mr. Rojas, you have Glenda Williford. Good morning.
Oh, sure, grinning.
Thought I saw somebody steal some coffee earlier.
It wasn't me. Somebody took it on my stuff.
Good morning, ma'am. Are you Glenda Williford?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the motion?
She will, Your
Give me just a second to get that pulled up.
Our agreement, Your Honor, is for her to be on special leave safe.
Thank you. Sorry, it's taking a minute for my computer to get pulled up here. Okay, so Ms. Williford, in cause number 24, DCCR 1720, I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation December 3rd of 2024 for the second-degree felony offense of aggravated assault with a deadly weapon, and that was a 5-year deferred probation. Is that correct? It alleges that you violated your probation. Count 1 alleges
Judge, we've agreed to go on counts 3, 4, 7, and 8.
Thank you. 3, 4, 7, 8. Count 3 alleges that you provided a urine sample August 14th of 2025 that tested positive for tetrahydrocannabinol. Is that true or not true?
Yes.
True or not true? Count 4 alleges that you provided a urine sample September 18th of 2025 that also tested positive for tetrahydrocannabinol. Is that true or not true? Count 7 alleges that you failed to provide verification of entering and successfully completing the anger management program. Is that true or not true?
Sure.
And then count 8 alleges that you are behind in your court-assessed fees as of September 18th, 2025 in the amount of $688. And is that true or not true?
True.
Did you enter your pleas of true to counts 3, 4, 7, and 8 freely and voluntarily? And did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them?
Yes.
And do you understand if I follow this agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
Speak up, please.
Yes, ma'am.
And it looks like the agreement that you've reached is to remain on probation, but enter and successfully complete the special needs safety program. Is that your understanding?
Yes, ma'am.
And we've got probation here with us today. And is that the recommendation from probation as well?
Yes.
Okay. I am inclined, if I follow this agreement, to extend the probation by some amount of time, just based on the allegations and the time that'll be spent there. So I want to make sure there's plenty of time after that she has still on probation. State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Williford is not competent?
There you go.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 3, 4, 7, and 8 freely and voluntarily. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. It looks like there's some, everybody's willing to work with you, but I want to make sure you understand that we're going to send you to the special needs safety program as a condition of your probation. I'm going to extend your probation by 1 year, and this is going to be, hopefully, listen carefully to what I'm saying, okay? Because this is the second chance you're being given, and there will not be a third. So you need to take advantage of every opportunity that is being given to you. You're going to get help with drug abuse. You're going to get help with mental health, with everything you need to be successful when you get out of safety. If at that point you don't follow through and do what you're supposed to do, you're going to be back in here and you're going to be looking at going to prison for up to 20 years. You understand? You okay? Are you okay? You're getting white. She's getting white.
I had a statement prepared for you. explaining the only reason I was doing marijuana at this time is because of my cancer, my pain management for years. And I will promise you on Jesus' holy golden good soul that I'll never touch this shit again if you let me go home.
Are you seriously going to stand here and talk
No.
like that?
No, ma'am. I didn't mean to. I'm terrified. I'm so sorry. I just didn't realize how much trouble I'd get into.
You're on probation for a second-degree felony, an aggravated assault with a deadly weapon.
Yes, ma'am. I realize that. I was trying to...
There's all kinds of other ways to deal with issues. And there's definitely more respectful ways to speak to the person who could put you in prison for up to 20 years. I don't have to go along with this plea agreement right now.
I'm so sorry.
Okay. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Go back with the bailiff.
This moment in the courtroom is a perfect example of how quickly a second chance can hang by a thread. From the outside, this hearing may look routine, a probation revocation, a negotiated agreement, paperwork reviewed, signatures confirmed. But beneath that procedural calm sits a very real truth. This defendant is standing on the edge of a 20-year prison sentence, and every word she speaks matters. The judge is methodical at first, walking through the record with precision. The charge itself is not minor aggravated assault with a deadly weapon, a secondary felony. 5 years of deferred probation was already an enormous break. That kind of leniency is not given lightly, and it comes with expectations. Stay clean, complete programs, follow conditions, and prove you can live within the law. Violations. Laid out positive drug tests. Failure to complete anger management unpaid. Fees aren't abstract check marks. They are warning signs that probation is slipping out of control. Still, the system does something remarkable here. Instead of immediately revoking probation, the court considers an alternative. Special needs safety, treatment, structure, supervision. Another chance. The judge even signals openness to the agreement, despite the seriousness of the original offense and the repeated violations. That alone should communicate how close the defendant is to losing everything, and then comes the turning point. When the judge explains the stakes clearly, directly, and without theatrics, she isn't threatening, she's warning. This is your second chance, there will not be a third. Those words aren't dramatic flourishes, they're a line in the sand. The judge is spelling out reality. Comply, get help, take responsibility. The next stop is prison, possibly for decades. But instead of absorbing that warning, the defendant panics. Fear takes over. Emotion spills. Out unchecked, she begins to plead, justify, and invoke explanations that might feel sincere in her own mind, but land disastrously in a courtroom. The mention of marijuana use tied to cancer pain. The promise sworn in emotional language. The desperate request to go home. All of it happens at exactly the wrong moment. Courts are not allergic to emotion.
Ow.
Judges see fear and remorse every day. What they cannot tolerate is a lack of self-control, especially from someone already convicted of a violent felony. The judge's reaction is swift and sharp because she recognizes what's happening. The defendant is losing composure in a situation where composure is essential. Worse, she is speaking in a way that suggests she still doesn't fully grasp the gravity of her position. That's when the judge draws a hard boundary. Her tone shifts not out of cruelty, but out of necessity. Respect in court isn't about ego. It's about order, accountability, and safety. And a judge reminds someone that there are more respectful ways to speak to the person who could put you in prison for up to 20 years. It's not a flex of power. It's a reality check. And then comes the most chilling line of the entire hearing. I don't have to go along with this plea agreement right now. In that instant, everything freezes. The defendant's fate is no longer theoretical. The agreement. Her lifeline exists only because the judge allows it to. One more misstep, one more outburst, and the safety net disappears. Prison is no longer a future possibility. It becomes an immediate consequence. This is the moment where silence would have been survival. And to her credit, the defendant realizes. The apology comes fast. Fear is visible. The color drains from her face. Courtroom energy shifts as everyone understands how close this came to going very wrong. Ultimately, the judge follows the agreement, but not without making the lesson unmistakably clear. The probation is extended. Conditions are tightened. The warning is delivered plainly and on the record. This is not mercy without memory. This is structured mercy paired with accountability. What makes this scene so powerful isn't yelling or theatrics, it's restraint. The judge doesn't explode. She doesn't grandstand. She simply reminds the defendant and everyone watching that the justice system is patient but not endless. Second, chances are real. Third chances are rare. Fourth chances don't exist. This hearing is a masterclass in how the courtroom operates. When someone stands at the crossroads of rehabilitation and incarceration, the law offers tools to help, but only if the person holding those tools chooses to use them. Respect, self-control, and responsibility aren't optional extras. They are the price of freedom. For the defendant, walking out of that courtroom wasn't a victory. It was a warning wrapped in grace. For anyone watching, the message is unmistakable. When a judge gives you a second chance, the smartest thing you can do is stop talking, start listening, and never forget how close you came to losing it all.